I declare the House in committee for consideration of the Social Security Commencement of Benefits Amendment Bill. Mr Chairman.
Mr Speaker. Members, the House and Committee on the Social Security Commencement of Benefits Amendment Bill. The question is that Clause 1 stand part. Point of order, Jami-Lee Ross.
I seek leave for all clauses in this bill to be debated as one question.
Leave is sought for that purpose. Is there any objection? There appears to be none. The matters will be debated as one question. The question is that clauses 1 to 6 stand part.
Mr Chair.
I call Carmel Sepuloni.
Mr Chair, standing up to speak to this particular bill, I just want to speak to the purpose of it and then talk about the supplementary order paper that I have tabled and that I'm hoping will be supported by the House, Mr Chair. So I think one really important point to make before I even get started, and Ruth Dyson just found this little fact out, is that this bill, yes, it came to the House in 1998. That's where the technical error occurred. Now, the interesting part of that is actually the bill at that time went through the House in urgency as well. So here we are again, correcting a technical error that was made under urgency back in 1998. And I guess that's the danger of rushing things through, not having the advice that we need, not having all the checks and balances in place, not having the Attorney General look over it, not having a regulatory impact statement. Those are all of the concerns that we have when we look at a piece of legislation like this, and even more so because of the fact that the technical error was made in 1998 when this bill went through in urgency then. So, Mr Chair, I really do hope that in 17 years' time we're not back here correcting a technical error that was made when there was an attempt to correct the technical error that had been made 17 years beforehand as the bill went through urgency. So, as I pointed out to the House during first and second readings, the major issue that we support the fact that there needs to be some correction here. So we support the fact that a technical error has occurred and that needs to be corrected. Our concern here is the commencement date, which can be easily addressed by the supplementary order paper that I've put up. Why we're concerned about the commencement date is because of the fact that it closes out the opportunity for so many people to be able to have that natural justice and make a claim. We saw in the media in the lead up to this bill coming to the House today that the Minister has allowed in this legislation a window of opportunity for those who missed out on that one day between May 2014 and September in 2015, a window of opportunity for them to be able to make a claim. The Minister's statement is that because the government was knowingly acting illegally during that time period, then it's important that that particular group of people who may have been stood down and denied a day of pay, that they be given natural justice. We've heard from members in the House that, members of the House that are supporting this bill, that their belief is that because this is a technical error, that anyone prior to May 2014 shouldn't be given the same opportunity or the same level of natural justice. But we oppose that, Mr Chair, because actually it's not the fault of the beneficiaries over the last 17 years that there was a technical error in the legislation. And an example I used where the shoe is on the other foot, where the government still relentlessly is chasing money owed to them, is actually with respect to the NovaPay debacle. And so what we've seen in the media in the last week in that case is that $1.8 million is still outstanding to the government because people were overpaid during that whole fiasco, but that was not the fault of the people who were overpaid, and yet the government, because it's money that's owed to them, are relentlessly chasing that money. Now, here we have the government needing to make changes to correct the technical error, Mr. Speaker, but the way it can be read, Mr. Chair, the way it can be read, and I'm sure the perception out there for many, is that, oops, the government owes a whole lot of New Zealand citizens out there, doesn't want to pay out, so oops, easy option, let's retrospectively change the legislation so we don't have to give them the money. Oh, how great it would be for all those citizens that owe money to the state if they could retrospectively change the legislation so that they were no longer held accountable or liable for the money that they owed. And I'm thinking of those poor teachers that now have to pay back money that was overpaid to them because of a government disaster, which we call Novapay. Mr. Speaker, Mr. Chair, so the SOP that I have in front of me will delay the commencement of the bill by Mr. Chair
Carmel Sepuloni.
by 6 weeks. And that's the window of opportunity we had asked for right from the beginning. So as the Minister pointed out, and I've alluded to as well, we have tried to negotiate with the government over this. The reason for that is actually this technical error has been allowed to exist under both Labor and national governments. So it is an issue that we should be working together to find a solution on. The one area of disagreement is whether or not these people prior to May 2014 should be paid out. And so our solution to this is actually just to put up a supplementary order paper that would delay the commencement of this bill by 6 weeks, Mr. Chair. And as I said, that's all we said to Minister Tolley at the beginning. That's all we asked for, really, was that there be a 6-week period where those who are entitled to claim would be able to make or put forward a claim. So the actual explanatory note here on the supplementary order paper says the SOP amends clause 2 so as to delay the commencement of the bill for 6 weeks. This would give people who have been penalised by the incorrect payment of benefits a window in which to lodge a claim for back payment in line with natural justice requirements. So, Mr. Chair, there are some arguments that have been put as to why we shouldn't do that. One of those arguments is fiscal. The unfortunate thing is that we have no real knowledge of what the numbers are that we're talking about here because of the fact that there's no regulatory impact statement. No one's really analysed it. We were told by Alfred Ngaro that because this particular the elements of this particular bill were originally in the extension of the Youth Service and Remedial Matters Bill, that we might be able to find the detail in the regulatory impact statement there for these particular measures. But actually, I've gone through that regulatory impact statement. I know Ruth Dyson sitting here, she's gone through it. Annette King's gone through it. And there is nothing in here about the commencement of benefits side of things, despite the fact that actually the commencement of benefits part was originally in the extension of the Youth Services Bill. So I think Portal Williams has gone through the regulatory impact statement as well. So I need to point out to Alfred Ngaro, the Chair of the Social Services Select Committee, who pointed us in direction of this regulatory impact statement, that there is nothing in there about the elements that we're talking about today. So it is a real issue that we don't have a regulatory impact statement in here. No one can comment on the fiscal implications because of the fact that there's no evidence to say how many people have been affected, how much money is involved, and to top it off, Mr. Chair, what we do know is that a large number of people who might be eligible to make a claim probably wouldn't make a claim because of the efforts that they'd have to go to. And for some who maybe went on a benefit briefly but then went off and have been in work ever since that one period in their life where they may have found themselves unemployed and having to rely on a benefit, for many of those people, and those are the vast majority of people who go on benefits, Mr. Chair, they won't actually be wanting to put forward a claim. So, Mr. Chair, we're concerned that so many people are being shut out in this process. We do know that many of them would probably not even want to make a claim, but it's just the fact that natural justice isn't being given the opportunity to prevail. I hope that the government see the merits in having the majority of the House support them on a piece of legislation like this, particularly when it goes through urgency and it is a retrospective piece of legislation. And I hope, as Annie King said, not only that they see the merits, but also they see, therefore, the merits of supporting the supplementary order paper. It's a small ask from us. We will support the bill if the government or the majority of the House supports us with the supplementary order paper to delay the commencement of this particular piece of legislation, to allow that window of opportunity for all of those people who have the right to make a claim to make that claim, rather than shutting them out completely from the process and only, even though we're glad that they're doing this now, only honouring the claims that have already been made, or only honouring the claims of those people who are affected post-May 2014, when the government became aware of the fact that they were acting illegally. And I do just want to say that a lot of the national government MPs have stood up here today and said that there's a sense of urgency with getting this through, a sense of urgency, but unfortunately there wasn't a sense of urgency in May 20th, 2014.